So the Hockey Canada verdict came out this morning, and unsurprisingly, I think, to most members of the legal community, all of the players accused of SA were acquitted. And the reason they were acquitted had to do with the fact that the trial judge found the complainant, EM, to be neither credible nor reliable. And this is very different than the concept of looking at consent, or this idea that consent was vitiated by fear. That was what she said in her testimony, and that was certainly the issue that was argued. But credibility and reliability is the crux of any trial. For a witness to have their testimony be believed, they have to first be found to be credible, meaning that they are telling the truth, and reliable, meaning that their capacity to recall the events that they're testifying about was not compromised in any way, whether they, couldn't see what they saw very well because of a vision problem, whether they'd consumed alcohol, and so their memory was affected by alcohol. So the judge found both credibility and reliability to be a problem here, meaning that she didn't believe the testimony. And a lot of people are upset by this. A lot of people say this is inconsistent with the fact that we must believe survivors of SA. And I think we need to recognize that while we have that standard in our society, and it's important to have that standard in our society, we can never have that standard be the presumptive starting point in a criminal trial. A criminal trial is, at its core, yes, a search for the truth. And because it's a search for the truth, you cannot start with the assumption that because somebody comes into court and says this person did this illegal thing, that they must have done it until they prove otherwise. And if you start to bring into the courtroom the believe survivors rhetoric, what you're doing is you're creating that kind of a presumption. You're creating a presumption of guilt. And then you're no longer searching for the truth. Because demonstrating your innocence is not a search for the truth. It's not determining what happened. It's just trying to prove that what is said didn't happen. And it's very difficult to disprove a negative. Constitutionally in Canada, our system of justice requires that the Crown prove somebody's guilt before there can be a conviction. It is unconstitutional in Canada for there to be a burden on an accused person to prove their innocence. And the reason for this is because otherwise, you would have innocent people be found guilty. And if there is a risk with a presumption in law that an innocent person could be convicted, that is unconstitutional. So when we look at our courtrooms and when we look at what happens in our courtrooms, we have to understand that it's an artificial system that exists for a reason. And it's an artificial system that doesn't necessarily reflect all of the values that we have in society. It has all of the values, it reflects all of the values that we have for protecting innocent people from wrongful conviction. And even if you believe that these hockey players are guilty, even if you believe the testimony of EM, the judge had to be satisfied beyond a reasonable doubt that these incidents happened and that they were non-consensual. And the core of that came down to believing her testimony. And if her testimony could not be believed, then that's the end of it. If a judge has a reasonable doubt, they must acquit. All of this is to say, I don't think that we can look at these verdicts today and say that this is setting our system back, or that this is setting survivors back, or that this is inconsistent with the law around myths and stereotypes in sexual assault trials, or that the behavior of defense counsel was bad. Defense counsel did what they had to do. It's a hard job. It's a difficult job. And everybody in that courtroom had to suffer. Everyone in that courtroom suffered. That's what happens in a trial. A trial, it's called a trial because it's suffering. The lawyers suffer, the Crown Counsel suffers, the clerk suffers, the jury, until they were dismissed, suffers, and they probably still suffer from what they heard. The witnesses suffer, the judge suffers. Everybody in the courtroom suffers. But we suffer on purpose because we need to determine the truth beyond a reasonable doubt. We need to, as defense lawyers, challenge the credibility of witnesses to protect our clients from being convicted in circumstances where a reasonable doubt may exist. We need to show the pathway to reasonable doubt, if one does exist. We need to try to uncover that. And the judge doesn't do anything wrong when they find a person who says that they were SA'd not credible or reliable. Because again, these are artificial constructs that don't operate the same way that we can operate when we interact with one another in society.